We go.
Excellent. Thank you, Michael. And it's just after 5, so we might make a start. I'd like to welcome you all to this evening's event. Before we start, I would like to acknowledge that I'm hosting this event from the lands of the Gadigal people of the Eora Nation, and I acknowledge the traditional custodians of the various lands on which we all work today, and the Aboriginal and Torres Strait Islanders people participating in this event. So welcome, thank you again for attending. So our speakers at this evening's webinar, Banking and Finance Expert Witness Insights, are Michael Green SC, Barrister at Level 22 Chambers. With over 20 years experience at the bar, Michael is a highly sought after for high-level strategic advice in relation to complex and confidential legal and regulatory issues. Michael has appeared in the High Court of Australia, the Federal Court, State Supreme Courts, the Land and Environment Court and various tribunals, and he has experience participating in many mediations and arbitrations throughout Australia. Our expert this evening is Bruce Debenham. Bruce is a Director of Banking and Finance at Perks. And Bruce's experience is quite vast. He's a risk management professional who has been involved in the financial services and credit industry for more than 25 years. Bruce has worked in public practice with 2 large accounting firms, followed by 15 years commercial banking experience with NAB and the Rural Bank. Currently a director at Perks, which is a large second-tier accounting practice in Adelaide. Bruce leads the banking and finance team. And that team provides debt advisory and broking services for clients across a range of areas of finance from a variety of lenders. And we're lucky to have Bruce join us this evening. He has first-hand experience across a number of industries dealing with both customers and relationship managers. And as a result of this experience, Bruce knows and understands how customers and relationship managers both think and work. When at NAB, Bruce was the chair of the Lending Standards Review Panel, which was responsible for reviewing and opining on bankers who had breached policy and process and or engaged in misconduct. In terms of his expert witness work, Bruce has been an expert witness in over a dozen matters, engaged by a variety of parties to litigation, and has appeared as an expert witness in matters with a particular focus on what it means to be a diligent and prudent banker and how a diligent and prudent banker should perform their role. Bruce is also a member of ARETA, and in March 2019, ARETA published his paper entitled Diligent and Prudent Lending, It's Not That Hard. And we'll be circulating a copy of that paper written by Bruce to all attendees this evening with the slide deck and recording of this session. And also joining us this evening is Alex Edwards, a barrister at Level 22 Chambers. Alex came to the bar in 2014 and maintains a diverse practice, accepting briefs in all areas. He specialises in complex litigation in the New South Wales Supreme Court and federal courts and has extensive experience in the conduct of class actions. Alex has also appeared as an acting Crown prosecutor briefed by the New South Wales Department of Public Prosecutions and is engaged in and has provided advice to both non-profit organisations and community legal centres. So this evening, why is that? Thank you. This evening, Michael, Bruce and Alex will bring their depth of knowledge to the role of an expert witness and the work of an expert witness in banking and finance litigation. And so thank you, Michael, Bruce and Alex, for giving up your time this evening. Much appreciated for what will no doubt be an interesting and insightful discussion. So I'd like to kick off with you first, Michael and Alex, and just get your observations on expert witnesses. So as we know, there's a big difference between what is a subject matter expert and a person who has the ability to perform the role of an expert witness. So Michael, what are your observations as to the competency of expert witnesses in recent years?
Well, thanks, Erica. Experts come in all shapes and sizes, have all areas of expertise, and the best expert witness is not always the person that speaks most confidently or the loudest. It is someone that has style, gravitas, and someone is able to give a degree of the court and the tribunal or a tribunal degree of confidence. They know what they're talking about, and they're willing to accept that there's a possibility that their view is not necessarily the right view, so they're able to engage with hypothetical discussions. A lot of subject matter experts, the kind that we might get to fix our car or to give us advice about investments, don't always meet that requirement. They're set in their ways. So a lot of the best experts are those that are willing to engage with the possibility that they're wrong about the views they hold, and their ability to defend and explain those views to an audience that is not always an audience of peers, but an audience that may be very interested in what they have to say, but not always able to articulate what's troubling them about the particular view that the expert holds. I don't know what your view is, Alex, about any of that.
I think it's an interesting and opposite distinction that is between, say, a professional expert witness and a subject matter expert. The reality is, in many cases, you're going to have to find a subject matter expert in some very diverse or specified field where you won't be able to obtain someone who has regular experience in providing expert evidence. And in those cases, you just really have to be aware of the scope of legitimate involvement in the drafting of the report, which can be quite extensive, provided that what you're doing is translating that person's views into something admissible. And as the federal court has recently said in New Aim, it's prudent to disclose that, which I think is first, it's a good idea, and secondly, it's contrary to current practice. And it is a very interesting development that if you are, for instance, sitting down with an expert transcribing what they're saying into a report, and if the expert needs that assistance, I don't think there's anything wrong with that, provided the opinions are, of course, his or her own. You just need to be very clear with the court in the report that's what's occurred, and then you might be criticised.
Absolutely. Well, Bruce, you've had experience working with lawyers in a number of different matters. Do I click here? Yes.
Yep.
Yes. Next one. Sorry, can you go back one, please? Thank you. There we go. We'll get it together soon. So you've worked as an expert witness in numerous banking and finance matters, and I guess recently and in a more contemporary context, after the COVID lockdowns and given the current economic climate, we're likely to see an increase in refinancing and debt restructuring, and possibly an increase in insolvencies in the future. So what are your thoughts on what we're likely to see in the future regarding institutional lending guidelines and practices, and also regulatory compliance?
Thanks, Erica. Certainly, over the course of the last 10 years, there's been an increase in compliance with financial institutions. That started following the GFC, but was more prominent following the Royal Banking Commission. So you've seen banks take a much more detailed focus on their compliance requirements, which has caused, for example, applying for loans and what have you to take a lot longer than they usually did. And I can only see that getting more stringent, particularly in a rising interest rate environment. You've also seen, again, more so since the Royal Commission and obviously during COVID, less enforcement action by the banks, which again, I think is probably going to continue. Banks are a lot hesitant about having their names brought over the front page of Australian Financial Review. So, and I'm seeing this as well in the broking side of our business. So we have clients with residential lending, commercial lending, and asset finance, and that is only getting more difficult because of the compliance requirements.
And if we just move on to the next slide. We can see from this slide and the one following that we've got an overview here of many of the matters that you've been involved in. And you've been engaged in federal court matters as well as Supreme Court matters in New South Wales, Queensland, Victoria and South Australia. So in your experience, do most of the matters settle, or do you find yourself frequently being prepared for cross-examination?
So I'd go, I've been fortunate enough to be involved in matters where I've been engaged by the lawyers acting for banks, for lawyers where they've been acting for plaintiffs against banks. And I've also been involved in a few matters that actually don't involve banks. So in terms of the matters I've been engaged in, when I first started doing this, I was told that maybe 1 in 20 might go to court and you might be cross-examined, and we'll talk about that one later. That I've only been cross-examined once. I've been prepped for cross-examination on 4 occasions. So in terms of how many actually get settled in the ones I've worked on, the majority have either settled or something else has happened. But certainly I've been prepped in 4, but only 1 has gone to court.
Yes. And the one that went to court is the matter of Westpac Banking Corporation and Haynes. And I think this goes to Michael's point at the beginning of the session that, it's important for an expert witness to be able to defend their views, but also accept that their evidence may not be, the brief that they've got or the evidence they're going to give is not necessarily going to be completely aligned to the party that they've been engaged by. So can you tell us a little bit about the work you did in the Haynes case?
Yeah, so this was my first case. I was called probably 3 months after I started at Perks, after leaving the banking arena. And I was asked to do an expert witness report, which, well, what does that involve? And so went through what was involved, and I said, who do you normally ask to do these? And ordinarily it was retired bankers. And then I said, well, why haven't you approached a retired banker on this occasion? And the answer was, well, you're still working in banking, you're working independently at banks, so it suits you. And sometimes the retired bankers don't want to be cross-examined. And I said, oh, okay, so how many go to cross-examined? And that was the 1 in 20. So it was an interesting experience drafting a report, working with the lawyers and then with the barrister. The barrister on the matter was a very good barrister and helped me in terms of giving me guidance, which is very important. It was guidance. It wasn't telling me what to do, and how to prepare the report, how to structure the report, the language that you use, which again is very important, which I'll come on to later. But in that particular matter, there was one particular item in that I focused on, and it was interpreted differently by the lawyers that were engaged in me, which actually meant that I had to do a second report to actually clarify exactly what it was that I meant. And then the final thing I learned from that was the level of preparation that you have to do to be cross-examined.
What? Yeah.
We've got some.
Sorry, I think if you're
Yes, David.
Sorry, if you're joining us via Zoom, if you could all mute your microphones, please. We're just getting a little bit of interference from some of the participants. That would be great. Thank you. Sorry,
I was just saying that. So one of the things that I learned, again, was the amount of work you've got to do to prepare for the trial. You've got to know your report back to front and inside out, because you don't know where the questions will come from, and nor should you even try and preempt what the questions might be.
And I'm sure, Michael and Alex, from your experience, and as you touched on, Alex, you have to be very aware of the scope of your involvement in the report itself. But what are your views on then, if the matter does proceed to hearing, just assisting an expert to familiarise themselves with the court process and what they can expect to happen?
It's a good question, and it depends on a number of things. And again, coming back to that original distinction between expert and subject matter. I mean, everyone's an expert, but there are people who professionally appear in court, and then there are people who might do it a couple of times because they're a mushroom farm expert, you know, and it doesn't come up that often. But absolutely knowing the report, absolutely not trying to anticipate and close off lines of questioning. I think the experience of being, it applies to expert witnesses as well, the experience of being cross-examined can be very confronting because it's fine in theory, but then people go and sit down in a compulsive environment and everyone's looking at them and they're getting asked questions. And just walking through generally the process by which cross-examination occurs and what it's directed towards, and that I think a few practice runs can be very helpful. Sometimes it's good to you know, you do some general practice runs, then you do one that's a little bit confronting, just to make sure that everyone's taking the exercise seriously. That's my general approach. You know, it depends on the case.
Yes.
One of the things I think is most useful for experts is because often the expert report is written months, sometimes years before the hearing date, maybe a couple of months out for the solicitor to remind the expert to reread their report, to review the report, and if their views have changed, whether because of changes in practice or changes in understanding, or something may have come up that, for example, if the report is theorising about a future event, if that future event's occurred, then the report can look pretty lame if there isn't a supplementary report or some other explanation of it. So 2 months or so before the proposed hearing date, to have a look at the report again, think about it. It's always much better the expert corrects their own report than it's done for them in the witness box by the other side. And remind the expert at that time that they are under a code of conduct, so they're allowed to change their opinions, they're allowed to review what they've written, and then from that to start a discussion with the expert if there are changes about why those changes came about, so they feel confident in being open to the idea they can talk about that with the court or with the other side if under cross-examination. That's a very important aspect. The other important aspect of it is the trial run. It's quite easy to test experts without actually getting to the actual subject matter that the expert writes about through theorising about other possible parallel universal parable examples, which can teach the expert to think about what I've talked about, the counterfactual, think about it, get the expert to embrace the idea that they might be wrong, you know, even though they're absolutely convicted that they have a great conviction that they're right on this occasion, that may be possible in the world that they're wrong. And also something about the difference between expert evidence and evidence of lay witnesses, because a lot of expert evidence has a dual function. The expert is bringing forward material and highlighting lay material as being important. And so it's important that they understand the distinction. Because often certain experts, I'm sure it's not ones that experts direct, but certain experts that I've come across sometimes forget that they are only experts and they weren't involved at all in the transactions. They can sometimes own the transaction so much, particularly in financial transactions. It was like they were actually there. And that can both ruin their evidence because they become quite partial, but it also makes them less credible in terms of their role assisting the court. Because often that means that all they're doing no more than becoming a glorified librarian handing up documents to the court. And they become a spokesperson.
And that partiality is particularly important too, as you reference the codes of conduct and the it's, you know, the role of the expert and their duty to the court is something that has to be highlighted and reinforced along the way. And I mean, with matters such as the complex matters you've worked on, Bruce, and you, Michael and Alex, you know, experts just like lawyers get very invested in the matter and get quite close to the matter. So it's very important to remind the expert that their paramount duty is to the court.
Yeah, that's something that was when I first started doing it wasn't apparent to me, and obviously I was advised very right at the beginning that you're independent. Your duty is to the court and to the court only. You can't be an advocate for the party that's engaging you. And in terms of the preparation, even when you're preparing your report, I would encourage experts to read all of the information that you're provided with and really understand it. If there's any questions that are being asked of you by the party that's engaging you that you don't understand, you must question them. You can't second guess what it is that's being asked of you. And again, if there's any other information that you need that you haven't got that you could help you prepare your report, then you should be asking the party that's engaged you to provide that if they can. Of course, if it's not discovered, then it's not discovered. But certainly you should ask the question.
So that actually touches something else, which I'm sure we'll discuss, which is it's really important for an expert, if they can, to be very articulate about the assumptions they've made. So in other words, the unsaid things in the otherwise unsaid things in their report. Some of that's assumed knowledge that's taken to be part of the domain of the expert. The expert training means you assume certain things to have occurred. But there are some areas, some disciplines in which the assumptions are really important. I'll give you one example, which is not in financial services, but happens a lot in hydrology and other areas of science, where hydrologists, for example, use models, use complex modelling systems to model groundwater flows or flow through pipe. And so often the hydrologist is doing no more than operating a computer program and reading out what the result is. Now that can become a problem because the computer program is only as good as the model that's put into it. And the expert, the so-called expert, doesn't have any expertise about how the model was built, but has had an expert in interpreting the results. And so some of the assumptions the expert needs to make in that case is that the models work adequately or appropriately, and to explain some of the shortcomings. Then they can become an evaluative exercise for the court to see how much of that should be accepted as a body of knowledge or not. So where there's those areas of human computer interaction, complex models, happens in financial planning and services and the like as well. Experts need to be very careful about what's their own judgment and observation, and what is simply the application of an accepted model in the field, which may need to be updated. The example that I use of hydrology is important because with global warming, the flow rates and the amount of falls and the intensity of falls and the like change, and so that some of those models do need to be revised and some of the data points need to be rethought. And so understanding the weaknesses allows a court to understand the arguments for and against accepting that particular output. But it's true in a whole lot of areas as well.
Yeah, the other thing I'd say about assumptions is that, and I've learned this on a number of the reports I've been involved in, is that I've incorrectly assumed that the reader knows what I'm talking about because of my experience and my knowledge. And I've been advised, you really do need to spell out exactly what you mean in your report, Bruce, because others might not have that knowledge. And so you think you're going back to kindergarten almost to explain exactly what it is you're saying. But again, what is your responsibility? Your responsibility is to assist the court. So you can't assume that the judge is going to know X, Y, or Z about your particular experience or whatever it might be.
That's a great. So a number of courts ask for primers from the experts, a set or a glossary, particularly in patent matters, but in a whole lot of other matters now. It is a lot more work for an expert the first time they do a report in a particular field to prepare that, but it's a huge amount of time saved later if an expert can basically explain the field, explain the terminology and like it, and work through that.
And so is that something that you would suggest to experts working in matters, that's a good, if they intend to work as an expert witness, that preparing a glossary or a primer like that is a very useful tool to do, maybe in preparation of being engaged in a matter, to assist both the lawyers and then eventually the court when the report is considered and they're cross-examined?
Absolutely. It's primers or those kinds of summary documents or introductory parts of an affidavit where the expert discloses their training and expertise is hugely important. And the reason, of course, is, as we all know, is that courts rely on language and precision. The precision of terminology is something that often experts are a little bit loose about, particularly computer scientists would use 3 or 4 terms to describe the same concept, but it's true in a whole lot of other fields. And so being precise and indicating that you're using that term precisely is really important. And then, of course, terms can change. So if, for example, the ISDA terminology between different versions or different editions of the agreement change, then there's a need to indicate which version you're referring to. Same with standards. Which standard are you referring to? When you talk about standard XYZ, are you referring to the particular one? Why have you chosen an earlier and out of date standard from the current standard? Well, there's maybe a good reason, because you're dealing with facts that occurred before the new standard was adopted. So there's the need for precision helps, and preparing a primer, even if you don't use it in the form you've prepared it, is a very good discipline. It also means you can then identify the literature and other material that you need to put in your expert report to properly fulfil your obligation to the court about making proper disclosure of all the inquiries you've made. It's not true in every area, but it is true in some particular disciplines where that's critical.
So one of the questions, the points you made before, Michael, was use of language. So one of the other things I've learned during the course of doing this is don't use complicated language, use simple English to explain what you're trying to get across in the point that you're making. In terms of glossaries and everything, I make a habit of using one of those in every report I do, so that the reader knows upfront exactly what it is I'm defining and what I'm working on. The other thing I'd say as well is, and this is a service that experts direct provide, and it's one that I would encourage experts to use, is when you've been working on a report for so long, you can sometimes lose the tree, so to speak, and sometimes you might contradict yourself without actually knowing it. So having someone independent review the report for you, just to make sure it flows and it makes sense, that your references and cross-references are all correct, is important.
And I guess it's also important too from an admissibility perspective as well, because you don't want to get a report, and prudent lawyers, want to make sure that the report's going to comply with the rules of evidence and be admissible. And I think having that independent eye review it or counsel in a matter is really important, so that it's not blown up right at the end of proceedings. And I was going to say, Bruce, too, just with that Haynes matter as well, I guess that term prudent and diligent banker, that would have its own definition for the purposes of the Code of Banking Practice, I think it is, and having to go through and explain that.
And it's a good point, because the term diligent and prudent banker actually isn't defined. You make reference to the Code of Banking Practice. If it's a matter that relates to the NCCP, then that's one of the points you go to. And indeed, the policy of the bank at the particular time is important to determine, how Bank A works as a diligent and prudent banker might be different to Bank B. So it's important that in these matters that is defined, and there's a lot to it actually. That's quite an important part of the report, because it sets the tone for the matter or the questions that you're going to be asked, if it is around diligent and prudent banking.
So some of that, I mean, I don't want to, Alex hasn't said much of late, but some of that, those sort of questions in the primer can also be dealt with in the instruction stage, instructing the expert, so that the toing and froing between lawyers and an expert and the letter of instruction can often deal with those kinds of questions. What's the terminology? What things do we need to know to best understand your field? So often the briefing letters that I've seen haven't really gone to that kind of anterior knowledge that is the background knowledge that justifies or somehow grounds the expertise. And I think a lot more can be done in briefing experts to ask for that kind of material, maybe in a two-stage process. So asking the expert to provide that kind of material first up if you're interested in briefing the expert, and then for the lawyers to think about asking some questions that use that terminology, and then having a session potentially face-to-face with the expert to ask, are we asking the right questions in the right kind of way that makes sense to you? Because often the questions that come out when there isn't that process are so general or so out of the useful field of discourse that they're meaningless or they can be picked apart by an opposing expert because they make the expert look stupid, even though ironically it's not the expert, but it's the lawyer asking the expert those questions. So a lot can be said for taking the time to formulate the question in the language of the expertise and taking the time to test that. And again, as lawyers that are retain experts in particular disciplines become more frequent in that particular discipline, they know how to ask the question. So it's a continuous feedback loop learning for lawyers and obviously for experts as well about how to do it correctly. But having that two-stage process. So the best advice I can give is if you're trying to brief an expert on a new discipline that you're not familiar with, take the time to try to understand the bare bones of the discipline by talking with the expert or with another expert or often the client, or clients are experts in particular disciplines. Ask them about the terminology that would work and then use that to formulate questions or approaches. It can be very helpful. It also can be very helpful to ask an expert explicitly, often in the very first conversation you have with them, and often not in a documented way. What are the limits of their expertise? What are the adjacent fields? What do they feel uncomfortable about expressing an opinion about? Now, the reason you ask that in that form is it gives the expert permission to say, actually, I'm really uneasy about giving this kind of evidence. And then you can ask why. And sometimes it can be because I worked at that bank, or I'm going to have to trash my friends, or because it's out of my area of expertise, or it's going to be a whole lot of reasons that have nothing to do with their expertise, but they're very valid reasons. And that can help you identify that you've got either the wrong discipline or the wrong expert with the right discipline, or you might have a combination of those things. And you can also plan that there might be other disciplines that if you're going to prove the proposition you're trying to prove, you're going to need another, like a Lego set, you're going to need to connect up other bits of evidence that you haven't quite got. The example sometimes people give is the difference between a builder, an expert builder, give advice about defects, and a quantity surveyor. There are often times you'll need both, but there are times where one is better than the other, depending on the nature of the dispute. So understanding those kinds of issues is really important. And in financial services, asking an expert in cryptography about standard banking practice of banker and customer is not going to help you terribly much, but if you're getting to neo-banking, you might say, actually, there's a bit of a crossover there. What do we do about that? Anyway.
So I've, following on from that, I think it's really important if you're approached to be an expert in a particular matter that you're absolutely honest in terms of your experience. So you mentioned neo-banking. There was one matter that I worked on where part of my role, I could answer, and part of it I couldn't. And I was very uncomfortable going there. So I said, it's probably better that you don't engage me, you get somebody else. And what happened was they basically took the requirement for the neo-banking out of the instruction letter and so just focused on what I could actually answer. So it really is important that you don't accept an appointment where you might know the answer or you might not know the answer. And I'm working on one at the moment where it's this particular area of accountancy, not banking and finance, where there's certain parts I can address and there are certain parts relating to tax, for example, that I can't and don't. And I put my hand up straight away to make that point. The second thing, Michael, you mentioned about discussing the questions. In all of the matters that I've worked on, where I've discussed or had the opportunity to discuss the questions with the engaging solicitors beforehand, it's been the process has been far smoother than where I've been given the questions. Bruce, there's the questions, there's all the information. Can you go away and prepare your report? That invariably has ended in a disaster, to be honest with you. Yeah.
And I think just you can't stress the importance for experts of ensuring that they don't stray outside their field of expertise, but it's also, I guess, important for the solicitors to be live to the issue that, you might think you need one expert at the outset of seeking your expert witnesses on the matter, but then as you engage one expert, it may transpire, well, as you said in your example, I can't advise on the tax component of this, so there needs to be that I guess that awareness to the fact that you your need for experts might change depending on what the initial experts you engage say. Going back to just preparing for cross-examination. So obviously we've got the codes of conduct and the duty of the expert to the court and the importance of a robust report. But obviously the weight that a court gives to an expert witness's evidence and their credibility is important. Alex, I don't know if you've got any observations on what experts can do to ensure that, well, not ensure, but
Do their best. I think it's always important to have some perspective about the cases you're running and realise that a judge is, a very attuned but busy individual who, like anyone who's eager to get to the root of the problem, wants to understand the expertise. And a judge is very unlikely to find compelling expert evidence that he or she doesn't understand. And so I think forensically, it is critical that an expert in developing their evidence and developing their report do it in such a way that the judge with no background in that subject matter will be able to pick it up. And so that's in the process of report writing and the process of giving evidence is building blocks to be able to then not just say, this expert said this and I liked, the way he or her presented, but that the judge has confidence in saying, I understand what is being said and I find it compelling. One part, I don't know if we're going to get to it, about credit is also about appropriate behaviour in conclave.
yes.
We've got a slide on that.
Yeah, I think that's our very next one actually, and that feeds in nicely to working with other experts.
Well, playing nice, exactly.
Yes.
It's so important, and especially if people haven't, for in class action, say you have these forensic economists who do conclaves together all the time, and they're all pals and they're pros, and they just, you send them and they go. But if you haven't done a conclave before, it's an additional layer of strangeness on top of the already strange experience of giving evidence in court, because you have this artificial confrontational experience with another perfectly reasonable expert, who just by magic has the complete opposite view of yours, and working with that. And I think starting the conversation or the evidence with what do you agree on will establish a huge amount of common ground. And then you can focus in on, well, we both agree this methodology is correct, but specifically in this respect, we have a different view, and coming to that in a collegiate way is massily productive.
That, I mean, the two things about that also about conclaves is that a lot of experts meet each other in conclaves all the time. And some of the most bizarre conclaves that I've had are where the experts decide to rewrite the questions, redecide the issue and say, this is your outcome. It happens a lot in planning cases where the experts get together and then agree that the design could be modified in a particular way, which goes beyond their remit. But in any event, there's a whole lot of bizarre things that happen because they do it all the time. The other thing is because, the Australian expert market is quite small, there's often you'll find that you end up briefing, well, in my position, I'll meet an expert that I'll cross-examine one day and then a lead-in-chief the next. So in certain areas, the experts need to understand that they're actually going to be, their credibility depends upon the ability to come backwards. Like, this is not going to be their last rodeo. And so the idea of playing in well and being able to play the role of an expert and independent is critical if they want to have a career as an expert witness. And their behaviour in the past is just as bad as their current behaviour, because people look that up and do research on them thanks to the power of the internet, find bizarre things they've said in the past that directly diametrically opposed to what they're now saying, and they'll have to just sort of justify why they did a 180-degree U-turn and between 3 weeks apart or whatever. So in other words, experts have to have a coherence, have credibility, have that kind of grounding that allows them to do the role and realise they're just expressing opinions, but they have to truthfully hold those opinions. If they're a gun for hire, which some experts treat themselves as, they're a little bit on the edge of acceptable conduct, and it can be, they might survive for a while because they'll be incredibly entertaining to a court, and the court will find them incredibly helpful, but then they fall flat. But you see experts, tick-tacking. One way to solve that is that some experts, they just take cases on one side of the record or one type of matter. I always get a bit edgy when I find experts that just solely specialise to put one point of view. I mean, one example of that is in harm minimisation and gambling in credit or poker machine situation cases. There's two sides of the people only appear on one side of a record or the other. So, and often I think that lessens the utility of some of the expert evidence that's around.
You've touched on a few things there, actually, Michael, I wouldn't mind commenting on. Acting for one side. So one thing that I was taught very early on by Richard, actually, was Bruce, if this is something that you're interested in doing and you enjoy doing, try to get a balance in terms of working. You're going to be approached to work where the banks, the engaging, or the solicitors acting for the bank are the engaging solicitors, and there's ones where you may be acting against the bank. So are you prepared to do both? And how I landed on answering that really quickly was the fact that you are independent in your duties to the court. So if you go with that mindset, then you shouldn't really worry too much about whether you're on one side or the other side. In terms of conclaves, I've got two quite different conclaves that I've worked on. So one that went really, really well. There were actually three of us, three banking and finance experts, but it was facilitated by a barrister. And it was also, the barrister had someone taking notes for us. Alex, we did exactly what you said right at the outset, right, let's work out where you agree. That made the process so much easier, because then it was basically, right, this is where do you fundamentally disagree, or is there some a ground where you can sort of get a compromise or explain to the judge why, Bruce, you've got that view and the other person had that view. It worked really, really well, and where we disagreed, it was a really good discussion, and it happened to be that one of the fellows in there I used to work with. Anyway, what happened after that is the notes were provided. I was the person nominated to draft the report, the joint report. And I did that within, I think it was a day or two of the conclave, and it's important to do that as soon as you possibly can, so you don't lose what was said in the conclave. That was distributed around the three of us, and we got agreement and presented it in the time frame that we were required, because that's the other point. Ordinarily, you don't have too much time to do these. The conclave is on a certain date, and you've got a certain time frame after that, not a lot of time to prepare the report. The second one I was involved in was an absolute disaster, and that was four experts in one room, two banking and finance, and two experts that were doing the assessment of loss for the particular case. First of all, we shouldn't have been in the same room. The banking and finance experts were in one, but that's how we were instructed to go in, so we had to. On that first one, by the way, we had set questions. The second one, there were no set questions. We basically rocked up on the day and had a discussion, and it was a lovely discussion. It didn't get anywhere in terms of putting the report together. So we left. I left that conclave thinking, right, okay, we've got to start somewhere. So I nominated to write the first draft of the report, and we circulated it around the four of us. And now an important thing is the second point on that previous slide around being digitally literate. Three of us were quite well versed in how to use Microsoft Word. So I did the report, went to the second person. They marked up the report so you could see the changes and what have you. Went to the third person, they marked it up. The fourth person it went to had no idea about Microsoft Word and rewrote the report, and we lost everything. And this was like 2 days before it was to be provided to the court. And it was actually what the first of the three of us, we were actually embarrassed with what was handed up, but we had to comply. So we had this mad rush at the end to tidy it up. It was an absolute disaster, that one. So I would definitely recommend it. Comes at a cost, obviously, having a barrister as an independent person adjudicating or helping, and having that note taker. So basically, all they're doing is recording or taking notes of the discussion. It allows you to have a really open discussion without having to worry about writing this, that, and the other.
Yeah, so there are some models that are evolving in the federal court and elsewhere of referral out on particular questions to basically like a conclave that has an effect where the barrister might be briefed to intermediate between experts to come up with a view or a result. There are a number of judges in the federal court that have taken that approach. Another variant is the so-called hot tub. And there are a few hot tub variants. There's the hot tub where the experts can ask each other questions in front of the judge, which is always fun, which can sometimes be unpredictable. Economists love doing that, and some scientists in particular physical sciences disciplines like it as well. The best version of that I've seen is where the judge settles the areas of debate or topics for discussion before that happens. Justice Bergen, when she was the Chief Judge in Equity, when her Honour was Chief Judge in Equity, had that approach in a matter about why frogs ended up populating space and in a habitat. And so one of the questions is why the frogs crossed the road. It was one of the questions that actually came up in the case. But in any event, there were all sorts of disciplines, and before each discipline came into hot tub, Her Honour settled the questions with the parties, and then that was the area in which the debate could take place, which was actually a very effective way to understand areas of disagreement, and really why in some cases there was disagreement, because the starting assumptions for some experts were different to the others, and really they were in furious agreement if certain underlying facts were the same, and they're in furious agreement. And it really did test their ability to concede points.
Before we move into just chatting about or getting both sides of both views on how to maximise the benefit of an expert witness, I should just say, and I omitted to do this at the beginning in terms of my housekeeping, but if you're joining us online and you do have any questions, please feel free to pop them in the chat. And we'll put them to our panel at the end of the session, and likewise, of course, people attending in person are happy to take any questions that you might have. But I think this has been a really insightful discussion as to not only working as an expert witness in just the context of banking and finance, but expert witnesses generally and what's required of them. So I guess, Bruce, what are your views or ideas on how lawyers can best get the best out of their expert witnesses and maximise the benefit they can bring to a matter?
So thanks, Erica. Yeah, the matters that have worked well is where I've been engaged reasonably early on, and I understand, the parties getting an expert involved does come at a cost. But where you're engaged early and you've had time to prepare the report and read everything, as I said before, it turns out to be much better. There's one matter that I was involved in. I had to turn it around very, very quickly, and my personal view is I felt uncomfortable, because when you're rushed, you tend to make mistakes, and so certainly try and engage as early as you can. And one thing that I've never been engaged as a dirty witness, but I think there's an opportunity to engage dirty witnesses a little earlier, just so that the parties can understand, or the party can understand how, for example, banks work, how they think, what information they ask for. So a really good example is when you're asking for items in discovery. If you use specific terms, you'll get what you want from discovery. If you use banking terminology, you'll get what you need. Whereas if it's more broad, then in my experience has led to arguments around discovery. Well, that's not what you asked for. So that's what, because there's information on banking matters where this information should be available. From my experience, I know it should be available. and it's not coming forward. And so there's obviously some games being played in the discovery process. So if there's an opportunity to get some early experience of an expert to help in that process, I think that's warranted. But certainly get your expert and as Michael and Alex have both said before, work through the questions. I think that's really, really important, because then you narrow it down to exactly what is required of you.
Yeah. And perhaps for maybe some of the experts joining us today, Michael or Alex, maybe you can go through the difference between a dirty and a clean expert.
Well, I prefer the phrase shadow expert.
Consulting expert.
Consulting expert. I mean, dirty expert is really not fair to either the expert or what they're doing. It's like a lazy way in which people can learn the discipline without reading a whole lot of books, and it can save a whole lot of time, particularly in various areas. And it's very important, as new areas are opening up, it's very important to understand the terminology. You have to do that to be able to engage and to write convincing submissions, and also, of course, to ask the right questions. So experts that are shadow experts, consulting experts, or as you call them, dirty experts, are often very important to formulating cross-examination questions, working through the sorts of material that we need to bring forward in cross-examination, also just preparing generally. The important part, of course, perhaps the dirty and the clean, is the idea of the clean room. Not allowing keeping a clean demarcation line between the expert that is a consulting expert and the expert that is retained to give advice in court. So making sure that it's clearly documented if there are any communications, and those take place from the lawyers. The experts shouldn't have chats with each other. It's just not on. If they do that, there are other bad examples of that, but they have the same problem that was observed in the recent federal court matter where the lawyers were settling the report, changing it, moving it around. Yeah. So it's very helpful to get any expertise and any assistance you can get. For a lot of lawyers, that means Dr. Google is the method of choice for being your own mini dirty expert or consulting expert. But you can actually have you can do a lot more quickly by having a consulting expert that has an area of knowledge. They can also help you evaluate whether you're picking the right clean expert or the right disciplines, or you can ask the questions of that person that you don't really want to have to ask the expert you're intending to use in court, because it may cause that expert in court to form a different view, or it might be seen as meddling in the outcome of the questions or the answers. So. There's a very good strategic reason to do that, and if the stakes are high, then it's good to use those people.
I'd like to emphasise the importance of retaining a consulting expert at the outset. That is, if you're a plaintiff, if your case involves anything evaluative that is going to require expert evidence, was this reasonable? Was this what a diligent banker would have done? All too often that's spelled out in your pleading, maybe by reference to some kind of, there might be an insolvency report or administration report or whatever. You're drawing on something, but you don't have an actual engagement with a person, a live person who's telling you. And then you get the expert 2 years after you've started, and then you replay, for the third time and materially change everything. And it often is better to have a more precise idea of your case theory informed by an actual live expert at the beginning. And it's not a massively expensive process, because you're not getting them to prepare a report. Here's some chats, here's some documents you can talk.
When we have a chat and find out something about the discipline,
And I think it's sort of a bit of homework that people lose track of sometimes in the rush to prepare a case, but it's important.
Very important. Excellent.
It also can help you identify that there are ways to get that evidence in that doesn't require the use of any expert. In other words, that, to go back to your point, Bruce, that person can point you in towards documents that might assist in proving the factual case that might be sufficient. So it can actually save a lot of time, and as Alex says, it avoids the embarrassment of pleading a case that can never be supported to a case, you know, sometime down the track where you've finally had the expert report and you realise you've miscalibrated, to use that friendly term, miscalibrated the claim, and you need to make some adjustments, hopefully non-fatally.
And a really good example of that in banking and finance related matters is that every bank has a credit policy and process, and that's the start point for how the banker or the bank ought to have acted diligently and prudently. And often I get engaged and we haven't got that basic information, which is absolutely critical. And that policy and process does change during time. And so what might have been acceptable in 2001 isn't acceptable in 2015. And it's important to make sure you're referring to the, as you said before, the right policy or the right standard that applied at that particular point in time.
Well, we're running right up to 6 o'clock, but of course want to open the forum up to any questions that people may have. So if you are online, please feel free to pop them in the chat. But we have one from Jim.
Hi. So I was interested in the points about experts that tend to pick a side. Sometimes you can tell from previous court judgments that the best place is resume that's an extra of the report, go through each case and people decide their own. Counsel perspective, can you do that as a point? You end up with credibility across the donation on the other side?
No, you can never do it simply because they've chosen a particular side, but because it could be very good reasons. They might be under restraint, they might not, you know, they're in various disciplines. But you should always very carefully study the CV. Two things you should always look in the CV. It's like employing someone. First is jail time. So the first is where there are very long gaps. You know, are there 5 years? Is there a 5-year gap where they in their productive life? What happened there? You know, like just drill into that a bit. Can you make up what happened? Is there a 10-year gap? Is that explained? Are there reasons why they've shifted from doing discipline X to discipline Y? Why is that? Can that be explained? So both your own, start with your own, you know, your own witness to explain that, and then also on the other side, look at that. Then the other thing is that generally witnesses, particularly experts, try to purge their guilt by putting everything in their CV, including their changes of position. So you know, you only have yourself to blame if you don't check what they've written before. So look at that. If the case is important, check the material they've included, and then check what they haven't included by going to Google Scholar, into other material, have a look around, some research. Do some research in journals and the like. Always check it, because what's left out sometimes also very telling. Check their employment history. So check the sort of where they were, where they moved to, and surmise why that might be relevant or not. Now, that may be totally irrelevant depending on the discipline, or it may matter. So in some cases, what I've just told you is utterly irrelevant, but in some cases it can be very helpful. If it's in an area where they could have acted from the other side and they've consciously chosen not to, then that might be an area of inquiry. But it's very hard to impugn a witness for, you know, choosing. And they're not like barristers that have the cab rank rule where they've got to represent both sides. They might have ethical reasons. They might have strong convictions about why they will not accept a retainer as an expert from a particular side. So you just have to go with that. You know, you can't really smile. So that's a non-answer, but it gives you a little bit of a hint about how to go about checking things. You know,
I think much like law, it is often the case that people who are professional experts gravitate to one side or the other. Often that's just because they develop strong working relationships and briefing relationships with a particular side, just like a barrister might be primarily an insurance plaintiff barrister or primarily insurance defendant barrister. It doesn't necessarily mean that they're a bad expert. No. It will mean, as I said before, magically they tend to have a view on one side, you know, rather than the other. But that can be helpful because it informs you of their perspective and how they're going to come at it. It's not something that's going to get you anywhere in terms of cross-examination rights.
No, that's right. Yep.
You mentioned the new aim decision. Do you have any thoughts or guidance that you would offer in terms of how the solicitor involvement in the process of sort of preparing the report could be disclosed or going forward in the substance of the report?
I think it's a really, really interesting question. And I think it's good that the court is being alive to the reality, as it has been, at least for my whole time of practice, that some experts need a lot of assistance.
Yeah.
And I mean a lot, right? It doesn't mean that you're telling them what to say, but it might mean that they can't write a report to save their lives just because it's not what they do. There might be a vegetation management expert from Canada or something, you know, and it's going to be 6 months sitting there. So you might have to sit down in a room with them and facilitate that by saying, what do you think about this? You know, is this your view? How would it be expressed? Write it down. I think really, if you're doing handholding of that kind, then you should do something like I've been, the expert should say, I've been assisted in typing this report by a person. One of the real problems, I think, is that it is going to create difficulties for the usual engagement of the barrister with the witness, because the barrister is then possibly in a position of also being material witness. So if that's occurring, obviously ensure that someone is in the room with the barrister and they're speaking to the witness. I mean, you should always do that. But in this case, if it's going to be something disclosed, you don't want the report saying, you know, and Mr. Edwards helped me type it and no one else was there, because that's not great. But I think everyone involved in the writing of expert reports should very carefully read New Aim and have a think about how the involvement of the lawyers in the report can be explained both accurately and benignly.
Yeah. The other thing is if they do require secretarial or other assistance, that it doesn't necessarily have to be the law firm giving that assistance, so they can be outsourced. So there are ways of keeping it clean if that's the desire. So, but the reality is that experts are always tested, and sometimes questions are asked, and you know, and often the expert will say, "Well, actually, I can see that lacks clarity. That point lacks clarity, and perhaps I can express it in a better way." And so, yeah, it just requires that ethical dimension where the lawyers involved know not to overstep the mark. They can test the propositions, but at the end of the day, if they start touching the keys and saying what should be said. Yeah. But you know, there's a big active degree about that. And with experts, as Alex says, it's very different when the expert's never given evidence as an expert before, because you're schooling them in a whole lot of different things they need to know. But where the expert in question does it all the time, and there are very different considerations about it, you know, and the super pro experts that do it all the time in a particular discipline will say, well, I just need this document, this document, this document, can you give me this? And, you know, Value was a great example of that, where mysteriously the report's generated in a few hours. All right, that's
Any other questions? No.
Any audience questions?
I don't think so. I guess just before we wrap up, and something that we haven't really touched on in terms of preparing for cross-examination, getting the best or maximising the benefit of an expert witness is obviously in the last few years, we've moved into a world where hearings are conducted by AVL. Witnesses are required to appear online via Zoom, different forums, depending on which court you're appearing in. Bruce, have you seen any sort of unique or specific challenges that arise when having to give, well, I guess?
I have. I haven't had to give evidence via Zoom in court, but I've been involved in a number of meetings with lawyers and barristers on Zoom, and I've got to say it's very, very difficult, especially so one of those sessions I was being effectively cross-examined on my report that I'd done, and there were a number of parties involved. And so I had 20 faces on the Zoom throwing questions at me, and you can't get a read of the room on Zoom. I think, what is it, 90% of correspondence is via body language, which you don't get on Zoom. So I found it very, very difficult. And sometimes there was one particular barrister who liked to think quite a lot before he asked this question, and just sort of wondering, am I meant to be answering the question, or is there a question, or is there doubt in terms of what I've responded to? So my preference would always be to do things face to face, because I think you get a better idea. But again, I understand we're moving into a different world at the moment, so it is what it is. But there was an interesting case, I'm sure you might know the name, where he turned up with a T-shirt on and he was playing on his phone when he was in the court, and that's just inappropriate behaviour, whether you're on Zoom or not.
Or not, yes.
So one of the issues that comes up a lot in experts giving evidence is, can they watch the evidence given by the other expert? And that's an interesting question, and really depends on case by case analysis of that. But often the expectation of courts is the expert should listen to each other, give evidence. And certainly during the COVID period where people do things by video, that was an accepted point. Just going back to your point, Bruce, about on Zoom. So when in the great COVID period of lockdown, where everything happened online, there was often experts cross-examining. I was cross-examining an expert, or I was leading my expert in chief, and the opposing expert was also on the Zoom, so I could watch the facial expression of the opposing expert, which is a bit hard when you're facing forward, the experts behind you. You have to reach, but it is because that was one of the few benefits. Oh, there are benefits of Zoom, but one of the few benefits of using that kind of technology, you can watch every nuance of the expert. As one expert was saying something, the other expert's facial expression changed, you can pick up on that. So
just put some mirrors on the left hand.
yeah. I just get the juniors to tell me what's happening. All right, but that's that becomes an interesting challenge, and you can see in disciplines how experts don't play with a poker face in the back of the court. And that's another point, which is in court or otherwise. Always remember that the judge is watching and can see everything, everyone in court, whether they're participating in the box or at the back. And an expert is just as much of the process as anyone else. So if the expert is grimacing, or as you say, coming in T-shirt or whatever else, it can affect their evidence later, in the sense of how much of a running start they have to lead up to in terms of the evidence. So think about demeanour in court for everyone, and also think about, if there are issues, think about it on poker face. One of the tendencies of some experts become very involved, where they start sending sheets of paper flying forward the bar table, and that can be very helpful in terms of cross-examining experts. And often that expert behind can ask really good questions. And I've had many good questions handed to me that have gone, actually, that's a great question. But just work out how to moderate that if you're behind, and how you do it so it doesn't look so desperate. Anyway, that's still a good thing. Yeah.
Well, Bruce, Michael, Alex, thank you so much for giving up your time this evening. I think that's been, as I say, a really interesting and insightful discussion on the role of the expert witness from both an expert witness's perspective and counsel's perspective. And I'm sure others will agree. So if you're joining us online and in person, we'll circulate a copy of the video, the slide decks, and also Bruce's Arita paper as well. So thank you, gents. That was excellent. And I hope everyone enjoys their evening.
Thanks.
Thank you.
See you later.